Welcome to the Disability Benefits channel, everyone. Today we're going to talk about what's in my Social Security disability hearing file. And we have with us two of our team members, paralegal Kelsey. Hi, Kelsey. And Katy. Hi, Katy. And they will be listening in, asking questions at the end, and I encourage everyone to do the same. There'll be a time for questions at the end, or you can just type your questions in the comment section below. All right. Okay, so what is in your Social Security disability hearing file? Well, first of all, let's talk about what is your hearing file. And that is, well, Social Security's paperless now. They use all scanned documents. So they have a system called ERE, where all of your records are going to be. And that's called your e-file. What kind of things are in your e-file? Well, before you request a hearing, medical records and forms you fill out, and that's it. After you request a hearing, it's records, forms, and Social Security medical decisions, your complete earnings history, and some other miscellaneous forms. Who gets to see your e-file? Well, before you request a hearing, you can't see your e-file. Only SSA employees and your lawyer or other representative can see your e-file. After you request a hearing, that's when you can see your e-file once it's put together. And that usually takes a few months for the hearing office to put the e-file together. And then Social Security employees, your lawyer, and you can see it if you request a copy of your CD if you are unrepresented. And if you have a representative, then that representative is going to be able to see your e-file and tell you what's in it. How is my e-file used at hearing? Well, the OHO staff, hearing operations staff, will assemble the e-file. It's called folder assembly. And they will take the documents, they'll look at all the documents that are in the e-file, and they'll choose which ones should be exhibits so that the judge can see them. If it's not marked as an exhibit, the judge will not consider it. That's a very important point here, that if it's not an exhibit, the judge won't see it. So, I mean, that is the most important thing in a hearing, is that the judge sees all your medical evidence that proves you're disabled. And then at your hearing, the judge will ask, well, is the record complete? And at that point, if the judge closes the record, then the judge won't consider any other evidence besides what is exhibited in the e-file. This is what we see when we log into the e-file. We get access through ERE as representatives, and when we enter ERE, we will get to see what is in your e-file. This is the first page. We can get status reports on all of our hearings, and we can access claimant's electronic file. That's how we see your e-file. And this is what it looks like. That it's divided up into folders, A, B, D, E, and F. The C folder is actually internal Social Security messages, and no one except Social Security employees are allowed to see the C file. Now, the C folder, sorry. So the C folder, it could have important messages in it about your case, but that is under Social Security rules. No one is allowed to see that part of the E file. So the payment documents, decisions, those are the medical decisions in your case. That is where Social Security will write like a 12 or 13 page decision that lists all of your severe impairments, everything you've alleged, everything you told Social Security, that's why you're disabled, is in that decision. And then the Social Security disability examiner and any doctors that they hire to look at your records will decide whether those severe impairments mean you cannot do any kind of job. So those are pretty important documents, only because it's an opinion from a doctor that the judge has to consider when the judge makes a decision. So if those doctors say that you're not disabled, that's what the judge is going to use to deny your case. If the judge feels that you're not disabled, that's what they usually use. Now, sometimes those decisions say you are disabled, but Social Security didn't apply the right law to that doctor's decision. And then at that point, the hearing is usually pretty easy, but the judge doesn't have to agree with even the Social Security doctors. And the judge will tell you, I'm not bound by the decision that Social Security has made in the past. I'm going to make a whole new decision. Then the jurisdictional documents and the notices, those are just notices regarding your hearing, usually what the hearing office asked for from you. They're not usually very relevant at the hearing. That folder will also have the fee agreement from your representative and your representative paperwork called the 1696, where you appointed your representative. If you don't have a representative, then there's not going to be that paperwork. D, non-disability development, that is generally your earnings record. So what kind of jobs have you done in the past? How much money did you pay into the Social Security system? What is your disability payment going to be? That kind of thing. And then E is disability related development. Mostly those are forms you filled out about your functioning, and that's where the Social Security judge will find what you have said in the past about your condition, how your condition affects your functioning, and the judge will match that up with what you're telling him or her during the hearing, and also against the medical records, what your doctors say about your condition. Speaking of medical records, that is the F folder. F folder are medical records. That is what wins or loses a case. Medical records. Incredibly important that all your medical records that are all your recent medical records during your time of disability are submitted to the hearing office. Now, and then that brings us to the next point. This case document section will tell tells us what's been submitted. Okay, there are scanned documents in here. And then the exhibit list, that tells us what the judge is going to consider. So the important documents must make it from the case documents section to the exhibit list. And we do, as a lawyer and paralegals, we do multiple checks to make sure that those medical records got exhibited. All right. And this is a sample of what the folders look like. This is the case document section. As you can see, some of the, if you look at the exhibit numbers in the middle right hand of the page, some of those documents have not been exhibited. So for example, outgoing ODAR correspondence has not been exhibited. So generally that kind of thing is not relevant for the hearing. So I wouldn't object. I wouldn't say anything to the judge about that. But if that were an important medical record, then yes, I would say, Your Honor, there's an unexhibited document in the case document section. Could you please make it an exhibit? And a judge has never told me no to that request because they want to consider everything that's important. All right, and this is the exhibit folder. As you can see on the left side, all of these documents have been exhibited. So this is what the judge is going to consider. The Social Security decision is called the disability determination explanation. And that is what I was talking about earlier, that the judge will consider as a medical opinion. All right. Okay, great. Well, like I said in the beginning, if you have any questions, please type them into the comment section below. And Katy and Kelsey, do you have any questions?
Questions?
No questions?
I just have one question. So if something is not exhibited and it's like the day before hearing, is it like just something that's quick and easy to send a message to the judge asking them to exhibit it?
Yes, that's a great question. So Kelsey just asked, if you didn't hear, if a document isn't exhibited the day before the hearing, is it easy to call the judge and tell the judge that something's not exhibited? And no, it's not easy because it's very hard to reach the hearing staff to tell them about exhibits or documents that aren't exhibited. What I usually do is I wait until the hearing, right before the hearing starts. The judge is going to ask me if the record is complete. And at that point, I would say, no, Your Honor, the record is not complete. There is a document in the case document section that should be exhibited, but it wasn't. And the judge will, and that's very easy. The judge will just click a couple times and it will be exhibited. Great question. Great question. All right. So if there are no other questions, thank you everyone for taking the time to watch this video. If you like this video and you want to see others like it, subscribe. It's the red button somewhere on your screen. And like I said, leave us a comment or a question, and like or dislike the video. That's the up, down thumb. And we will see you next time. Bye.